So what happened on the 25th of September? In case you don't know, it was a post-trial motion hearing in Manhattan federal court about whether to toss Diddy's 2 prostitution-related convictions or grant a new trial before his October the 3rd sentencing. Now, Diddy walked in slimmer, tan jail suit hanging off him, blew a quick kiss to his mom, and then tried to blow up the verdict. His lawyers pitched a bold spin. This wasn't pimping, this was private adult stuff, sometimes filmed, sometimes not, and filming equals protected expression. Prosecutors fired back. Stop the poetry. Flights, hotels, payments, intent. The law cares about transport, not your home movie catalog. The judge pressed both sides, tossed a few sharp hypotheticals, and didn't rule on the spot. So here's the tension. Does this motion nuke the counts before October the 3rd, or are we headed straight into years behind bars talk? I'll walk you through the courtroom energy, the timing fight, the commercial sex debate, the First Amendment gambit, and why the pattern over the years might be the real weight. But first, what exactly went down? So the line outside started before sunrise. Press badges, whispering, elbows. Inside, it felt tight, like everyone came for a last look before the finale. Diddy walked in looking slimmer, tan MDC jumpsuit instead of the court-approved sweaters and slacks. Quick smiles to the family row, mom, kids, close circle, all locked in on him. The room had that mix of curiosity and judgment you only get when a verdict already happened and someone's still trying to flip the scoreboard. Stakes were clear. 2-man act counts that could turn into real time with sentencing already penciled in for next week. He sat steady. No outbursts, just small nods as his lawyers lined up their arguments. You could feel the split. Defense, talking privacy and consent. Prosecution, ready with travel logs and receipts. The judge watched everything. Pen tapping, eyes moving fast. Atmosphere said, big swing, not victory lap. And then we got the first clash. Did the defense even show up on time, legally speaking? First clash, timing. The government called it a second bite of the apple, saying these challenges should have been raised before trial under Rule 12. In plain English, you don't get to lose, then retroactively move the goalposts. The defense pushed back, hard. They said those bigger acquittals, racketeering, sex trafficking, changed the legal landscape, so some arguments only make sense after the verdict split. The judge drilled into that. Is the door even open to hear this now? He kept circling the same point. Procedural bars aren't small speed bumps. If Rule 12 blocks you, the rest is noise. Defense tried to thread the needle. The posture is unique, the instructions were flawed, and we're raising constitutional issues, not nitpicks. Prosecutors answered, none of that excuses lateness. Energy shifted. If they lose on timing, the fancy theories never get airtime. The judge didn't tip his hand, but the questions felt skeptical. And with that hurdle barely cleared or not, the room pivoted to the meat. Was this commercial sex or something the law doesn't cover? Defense swung at the core. This wasn't pimping. He didn't run a ring. He didn't profit. Money was for time, not acts. Clean, neat, and, according to prosecutors, totally missing the point. The law doesn't ask who got rich. It asks why people were moved and paid. Commercial means anything of value. Flights lined up with hotel nights. Hotel nights lined up with, well, you know. Charts, wires, messages, the paper trail did a lot of the talking at trial. The judge tested the edges with a blunt hypothetical. If a businessman bankrolls a client's night with a sex worker, does that make the businessman liable? Defense said no, he's just a consumer, not a transporter. Government said yes, if you plan it, fund it, and direct the purpose, you're in the zone. That word, intent, sat in the air like a weight. If the travel and the purpose are glued together, the label sticks. And that set up the next fight. Can you be liable without physically moving anyone? Prosecutors framed it simple. You don't need to carry someone over a state line to be on the hook. You can cause it, fund it, direct it, coordinate it. That's aiding and abetting. That's willfully causing. They pointed to messages and voice notes from trial where they say plans weren't spontaneous fun, but scheduled logistics. Flights booked, rooms set, people lined up. Defense tried to shrink the target. Intent here is about prostitution, not just travel. They argued watching, filming, paying bills isn't the same as transporting for sex. The judge pushed. If you know the purpose and you bankroll the movement, aren't you effectively moving the pieces yourself? Defense insisted he was a viewer, not a mover. Government answered, viewer or not, he built the stage and hired the cast. If the plan is the point, the planner is liable. You could feel the room split again, privacy versus purpose. Then came the curveball everyone waited for, the First Amendment amateur porn shield. Defense rolled out the bold card. This was private adult stuff, often filmed, and filming is expressive, so protected speech. They painted him as a consumer producer of amateur content, not a trafficker, and said the government was criminalizing what happens in a hotel room because a camera was present. Prosecutors swatted it down. The statute targets transportation for paid encounters, not videography. You can record your life. You can't fund interstate trips for sex and call it art. The judge pressed the weak seam. Not every encounter was filmed, right? If the shield is, it's just content. What about the nights with no camera? Defense tried to broaden it. Consumption is lawful. OnlyFans exists, and adults have privacy rights. Government answered with the backbone, the state's interest in regulating prostitution and preventing related harms. Translation, filming doesn't bleach intent. The room could feel it. Interesting theory, thin cover. Next question. Even if the theory fails, how big does the pattern make this? The government zoomed out and hit the pattern. Not a one-time stunt, but years of trips, rooms, and paid encounters stitched together. Their closer, planning, directing, and repeating it for a long stretch makes intent obvious. They also reminded the judge of those ugly moments the jury heard about. Context, not new charges, arguing it shows control and risk. Defense tried to rebalance the scale. Guidelines point low. He's already spent a hard year in Metropolitan Detention Center, and the court can't inflate punishment with conduct the jury rejected. They warned against using acquitted stuff to pad time. Bottom line, two pictures. Prosecution paints orchestration, defense paints private consenting adults and overreach. The judge listened, pen tapping, no tells. If the motion dies, the real fight is the number. The feds floated 4 to 5 years, defense pitched near time served. And one more lever was waiting on the table. The letters. Family letters begged for mercy. The mother's note was the emotional anchor. Age, regrets, a plea to see her son free while she still can. The sister called for a turning point, not an ending. Then the inmate notes. One man said Combs calmed units and pushed people to do better even with nothing to gain. The defense memo stacked it all with backstory, loss, addiction/medical notes, redacted, steady work history, and hammered the theme. Consenting adults, no force, no profit, and punishment already felt in a tough facility. Prosecutors didn't blink. They said the scale and planning deserve real time and warned the court not to erase the verdict with sympathy. The judge closed with a neutral, soon, and a practical, see you next Friday. Translation, motion still pending, sentencing still circled on the calendar, unless he surprises everyone. All right, that's where it stands. No ruling, clock still ticking. If the judge wipes those counts, everything flips. If not, we're staring at a straight numbers fight. Years versus near time served. The arguments are locked. Timing, on commercial intent, who really moved the pieces, and whether filming changes anything. Letters paint a softer picture. The record shows a long pattern. Next week decides which version wins. I'll be on this the moment the court moves. If you want the fast breakdown when it hits, tap subscribe and turn on alerts. Drop your take in the comments. Did the defense make a real dent, or did the judge's questions tell you all you needed to know? Thanks for watching, stay sharp, and I'll see you right after the ruling.